Thank you very much. I'd like to say that we have saved the very best for the end of the day, and that is the rules of professional conduct. And for those of you like me that didn't graduate from law school last year or 5 years ago, what I'm going to do for the first part of this presentation is take you through a romp of the rules of professional conduct. It will be primarily those rules which are applicable to difficult, not so much difficult litigant pro se's, but more difficult litigant or difficult traits that attorneys may demonstrate as they are in the litigation process. Now, before I came to the Bar Association about 8.5 years ago, I did practice in private practice for almost 20 years. And I will say that I have firsthand observational skills of difficult clients, opposing clients, and opposing counsel, and dare I say, difficult adjudicators as well. Which is one of the reasons why I think to a certain extent I very much like the rules of professional conduct, and some would say I'm crazy because I love them, because what they actually do is provide some very good guidelines about what to do in particular situations when you're concerned or someone else that you're dealing with is concerned about, for example, scope of representation or conflicts of interest, etc. So because of that, we're going to be spending the next hour and a half or so just taking a very deep dive into the rules of professional conduct. And I'm sort of the numbers person here. We'll be both up here on the podium, but also on the panel. I will be tying as many concepts as I can to very specific rules. And I think everyone in this room is sort of a rule lover anyway, based on the kinds of law that you practice, but I'll be here to take responsibility for the rules of professional conduct. And although I'll be talking about the RPCs as they specifically relate to difficult litigators, I reserve the right to throw in any darned RPC that I want to as we kind of go through the discussion process. By that, I also suggest and recommend that you participate in this process as well. So particularly when we get to the hypothetical aspect, we encourage your questions and your comments. In fact, you'll get an opportunity to talk to your neighbor about some of the issues that come up, and then an opportunity to expand upon what we're saying, or even correct us, or even challenge us. I love challenges, and no, I'm not a marathoner, but I do like good questions that pertain specifically to what we're talking about. So we encourage, and I encourage your questions and comments and thoughts as we go along. But without those questions or comments or hands being raised, I gotta warn you, I'm gonna plow through these materials as well. So as I mentioned, I did spend a lot of years in private practice, first beginning with sort of a traditional downtown Seattle firm and then moving into my own practice. I have to say that one of your esteemed colleagues was one of my office sharing mates here on the front row, Jocelyn. We were way back. So it's great to see Jocelyn and to all of you here as well. We have at the Bar a professional responsibility program. We have over 40,000 licensed legal professionals. We have a very qualified stable of prosecutorial attorneys. There's approximately 15 attorneys that do a very good job. Unfortunately, they are kept busy full-time. Prosecuting attorneys that decide to help themselves to trust accounts and overall just drop out of sight for their clients. We have a professional responsibility program, and we have one professional responsibility counsel for all 40,000 licensed legal professionals, and we're here today to talk about that. That's my role for the Bar Association. Even though that's my role, I want to say I'm not saying anything officially for the Bar. This is sort of the RPCs according to Jean Marie. And the Bar, there are discipline cases, there are advisory opinions, there are other resources that I invite you to look at as well. Some of you may already know, but I'd like to have all of you be aware of what we call the ethics line. It used to be called the hotline, and I already corrected my esteemed co-panelist, John, and said, nope, we don't call it the hotline anymore. We try not to get everybody all in a lather because we're not calling back in 6 hours. But really, here's what I did it. I did it. You put something in my coffee, I'm pretty sure. So the ethics line is a confidential phone line for attorneys or anyone who is a licensed legal professional. I say that because we have triple LTs and LPOs, and all of the judicial officers have an attorney license. And they can call that line. It's very old school, it's phone. It's not, I don't do emails, I don't do faxes, I don't do texting. It's all about calling the ethics line about your questions and concerns about your perspective ethical conduct. And I encourage all of you, if you have a question or a quandary, to reach out and get the resources that you have in your own office and in your own facility. But if you're looking for a confidential comment or thoughts, please feel free to call the ethics line. And I will tell you, I talk to attorneys every day that say, after we have a conversation, they go, that's exactly where I was going to go, but it just feels really good, if you will, just to have someone else talk about the RPCs and to kind of view them in the same lens that they are. Because what's interesting about the rules of professional conduct is they're a code. They appear to be really clear until you get that one big problem. And then you read through them and you go, I have never seen the word reasonable so many times. This should be a reasonable inquiry. This is sort of is this a reasonable approach? Well, what the heck does reasonable mean? So sometimes having that conversation is very helpful. We go to great extremes to keep the calls confidential. They are transcribed for me, but at the end of each day, we actually get rid of all of those kind of calls. The only reason why we transcribe them is to make sure that they are a barred licensed legal professional, because we can't have the public coming in and asking for advice about what their lawyer has done. And we also need to make sure that it's not a lawyer that's making an inquiry about another lawyer's conduct. That's not really what my job is. It's not to help lawyers sort of build a case about what their opposing counsel is doing. Although many lawyers kind of say, well, after I tell them that, it's like, well, hypothetically, if that were me, it's like, yes, and I was born yesterday, but anyway. So we handle, and I say we because I have a backup attorney, almost 3,000 calls a year. So I'm on the phone a lot. I talk to a lot of attorneys and some judges, and throughout the entire spectrum of practices and experiences and problems. I really enjoy it because it's like having an oral exam about 10 times a day. When I was in private practice, I was in like 4 or 5 areas of practice. I wasn't a generalist, but I had very specific practices that I did. In elder law and disability, I worked with a lot of families and individuals who were disabled, and worked a lot with the elderly, did a lot of estate planning, that whole piece. But I'm talking to attorneys that have very disparate practices that I did, and they've got to do a quick little 1 or 2 minutes to kind of educate me on the topic, and I do like that. We really believe, those of us that work in this program really believe in attorneys, and we believe in what attorneys can offer and protect the public in the roles that we perform and what we do. And I was just mentioning earlier this afternoon, if any of you haven't read the preamble to the Rules of Professional Conduct, just take a moment or two to take a look at it. It's very, very inspirational insofar as, kind of harkening back to our law school days and why we decided to go to law school, etc. So I encourage you to use the ethics line as a resource. I encourage you to be always thinking about the rules of professional conduct. I do, and you can tell because if you look at this dog-eared copy of the rules of professional conduct, I practically put this under my pillow every night. I mean, these are the rules, these are the comments, and honestly, every time I read them, and I just reread a rule this afternoon, I do pick something up that's very different about a rule or a comment. So I encourage you, obviously they're on the court's website, you can go online, you don't need a hard copy, but do look at the rules, especially when you're not in a crisis state. Take a look at them just kind of on a periodic basis, or after you've had an ethics presentation, and take a look at what some of the issues might be for you that you may be encountering. So let's start talking about some very specific rules And let's talk about sort of your basic meritorious claims and contentions. This is not something which, is ordinarily sort of the subject of discipline, but, it's very interesting because it essentially says that a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there's a basis in law and fact for doing so that's not frivolous. Wouldn't we like it if everyone really followed that rule in that regard? But that is very specifically a rule of professional conduct. However, comment 1 speaks to the fact that, and I'm going to go back to 3.1, that the advocate has a duty to use legal procedure for the fullest benefit of the client's cause, but also a duty not to abuse legal procedure. So this is a thread which you will find through most of the rules of professional conduct, and that is, yes, it's an adversarial system, but back in the day, the word zealous was in the rules of professional conduct, right? Because we were all supposed to be zealous advocate. We were all supposed to be hammering on behalf of our clients. Well, what happened? Zealousness became weaponized. And essentially, the American Bar Association recommended through their model rules, and also Washington adopted, the word zealous actually was pulled out of the rules of professional conduct. And it was sort of pay attention to what the rules and procedures are, but don't abuse the system in that regard. So instead of zealousness, we have, for example, 1.1, which is competency. And that is keep abreast of what your area of practice is, what you're supposed to do, pay attention to it, and remember you're doing it in the context of doing the best job of representing your client. We also replaced zealousness with 1.3. And 1.3 is diligence. So know what you're doing and do it promptly. Okay? Sometimes when you read these rules, you think to yourself, really? They needed to codify this? Aren't these kind of like good habits that we should have picked up a long time before we went to law school? But the answer is no, and actually, unfortunately, there are lawyers that end up being disciplined because of lack of competence, which will come up in one of our hypotheticals, and a lack of diligence as well. So lawyers are required, and this is still under RPC 3.1, to inform themselves about the fact of their clients' cases and the applicable law, and determine that they can make good faith arguments in support of their clients' positions. But it does not mean that even if the lawyer knows that that will likely not ultimately prevail, if it is arguable, it is not frivolous. So I don't know about you, but when I was in private practice, there was more than once when I was arguing for a client's position, I knew it wasn't a great argument. I knew that that's what the client wanted. I wanted to make sure it wasn't frivolous. I had a pretty good idea about how that was going to turn out. The important piece, I think, of meritorious claims and contentions and the way it integrates with the rest of the rules of professional conduct is another RPC 1.4. And that's communication. See, I promised you we weren't going to just stick to the rules that were on the PowerPoint slide. We're going to talk about all the rules. 1.4 is communication. So if you are going to, your client wants you to present an argument, or you are going to present an argument on behalf of your client, you know it's not frivolous, but you know it's unlikely to prevail. What is the first thing a lawyer should be doing with their client? Tell the client. Communicate to the client. And this gentleman is not in the front row because I asked him to sit here and answer that question, but I gotta say thank you. All right, so let's not be stunned, okay? Yes, tell the client. It's all about setting expectations to the client. I included in your materials the disciplinary statistics, and the vast majority of disciplinary statistics, the reason why clients or other folks, because our disciplinary process is very open, why do they file grievances? Because there wasn't communication one way or another. Either the lawyer failed to communicate in such a way that was appropriate, or the lawyer just stopped communicating altogether and moved on to something else. So meritorious claims and conditions. Candor toward the tribunal. We have a very interesting hypothetical which addresses this. But let's just talk about what candor means generally. It means that for every lawyer that is in front of the tribunal, They essentially cannot make a false statement of fact to the tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer, by themselves. Not another lawyer or not their client. But if they knowingly did this, they are to correct it, okay? That, if you read the rule, is not protected by RPC 1.6. It just says you, lawyer, are responsible for what you say to the tribunal. So for 5 cupcakes at the end of this presentation, who can tell me what 1.6 is and why am I referencing it? Take a guess, take a gander, particularly those that actually heard me present last week. Any guess about 1.6 is? Well, close, but not exactly right. And the answer that was offered was privilege. It's all about confidentiality, okay? So I think that confidentiality is really the core of the rules of professional conduct. It's all that attorney-client relationship, right? And that the client should be able to communicate and address anything that they need to or want to their attorney, and know that that attorney will keep that information with some limited exceptions under 1.6b, right? So you'll note that the first one is not protected by 1.6. So if the lawyer made a false statement of fact or needs to correct a false statement of fact that they made, that's not considered protected under RPC 1.6. You will find, however, that there is an overwhelming number of other pieces of the Rules of Professional Conduct where 1.6 actually does protect. Even if a lawyer knows that something is wrong or awry, it does protect that particular information. Let me address the privilege question, because I get this question often enough on the ethics line to recognize that particularly those attorneys that are not before a tribunal don't quite get the privilege piece. Privilege is evidentiary. Privilege is supported by a body of law. Privilege looks like, sounds like, and probably smells like confidentiality under 1.6, but it is not the same. It is in the context of a tribunal, and it has case law which does or doesn't support the waiver of privilege, okay? But confidentiality is, under 1.6, confidentiality is information relating to the representation of a client. And that has been interpreted as all information relating to the representation of a client, which means if that client walks through the door and you observe that their hair is green and they're wearing a purple shirt, because that client walked into that lawyer's office, they know that because of that attorney-client relationship, that is actually considered confidential under the Rules of Professional Conduct 1.6. Now that may have nothing to do with privilege. Okay, so I just want to kind of make sure that that's a piece. And for those of you that went to law schools where you were taught the ABA model rules of professional conduct or whatever the iteration was at that time, please know that Washington interprets 1.6 much more broadly, or put another way, much more strictly than the model rule. In other words, lawyers in Washington, practicing in Washington, are held to a higher standard of confidentiality than the model rules entail. So I always kind of do that as sort of like, be careful. So then there's the other piece of a lawyer shall not knowingly, got this interesting chord right here, fail to disclose a material fact to a tribunal when disclosure is necessary to avoid assisting or fraudulent act by the client unless the disclosure is prohibited by Rule 1.6. So there you're seeing sort of the interplay of the confidentiality of Rule 1.6 going to that duty of candor toward the tribunal. And the same goes with legal authority, and the same goes with material evidence, which is also protected under 1.6. Now this is not a presentation on confidentiality 1.6, but know that 1.6 has a number of exceptions to it under 1.6b. Know that there's only one mandatory exception, and that is if there's a risk of substantial harm to human life. All of the other exceptions are extremely limited. So if you think about confidentiality as all encompassing of that attorney-client relationship, the ability under 1.6b 2 through, I think it is 2, because they just added one, 2 through 8, you've got about an inch and a half crack in that door to actually allow, it's a permissive disclosure of confidential information. So the lawyer may refuse to offer evidence that the lawyer believes is false. And in comment number 2, this rule sets forth the special duties of lawyers as officers of the court to avoid misconduct that undermines the integrity of the adjudicative process, which is kind of like the justification for this whole duty of candor toward the tribunal. Now, this is when a lawyer is in a tribunal situation. So when you have an attorney, just as an FYI, that's in a transactional situation, or that is not preparing information that, so not all lawyers are appearing before judges and ALJs, right? I know it's kind of hard to believe, but there's lots of lawyers that do contracts, do property, they're doing a whole lot of other things. 3.3 does not explicitly apply to those lawyers, but it does very strictly apply to those lawyers that are in front of a tribunal. And if there's any question about what a tribunal is, it's very handy that it is defined in under terminology. So 1.0, capital letter A, subsection M defines what a tribunal is. And I've had some calls on the ethics line where attorneys, well, sort of an interesting distinction between a court order and a subpoena, and they weren't sure if under that tribunal the subpoena actually was equivalent of a court order or not, because the exceptions under 1.6 actually are delineated as to whether or not it's a court order or subpoena. So that was kind of like, we were sort of nerding out over that. And if anyone wants to nerd out over that at the break, just let me know. I'd be happy to talk to you about that for at least a half hour or so. But so the prohibition against offering false evidence only applies if the lawyer knows that the evidence is false. The lawyer's reasonable belief that evidence is false does not preclude its presentation to the trier of fact. So that's kind of a really interesting, almost like a circular expansion of what that means. A lawyer's knowledge that evidence is false, however, can be inferred by the circumstances. Thus, although lawyers should resolve doubts about the veracity of testimony or other evidence in favor of the client, the lawyer cannot ignore an obvious falsehood. So what that means is a lawyer can't kind of hide behind a certain amount of ambiguity when in fact the lawyer can't ignore that there are some very specific facts which would essentially point to the fact that that is a falsehood. So we've gone through all the sections of RPC 3.3. So now we've got 3.4, which is fairness to opposing parties. So this is again sort of branching off from the tribunal experience to the lawyers who are essentially in all contexts of their practice. So evidence. Very important under A, a lawyer shall not unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potentiary value. A lawyer shall not counsel or assist another lawyer to do so. And so there's this whole piece about a lawyer needs to make sure that witness testimony is not false. The lawyer has to obey the rules of a tribunal and court rules. A lawyer has to recognize that discovery in the context of litigation has to be diligent and it has to be proper. And in a trial, this is where this might be very specific to your context, it is misconduct for a lawyer to allude to any matter that the lawyer does not reasonably believe is relevant or that will not be supported by admissible evidence, assert personal knowledge, make some sort of statement as to the justness of a cause, the credibility of the witness, the culpability of a civil litigant, or the guilt or innocence of an accused. So this is where lawyers really can't go in there and substitute themselves for the trial of fact, if you will. There is an interesting case, and I want to just sort of bring that up to you. Let me just grab it here for you. It's called the Conat case, and got so many goodies here. Okay, so this was a discipline case. It's actually not in your materials, but it had to do with this. a respondent who was first a public defender, then a prosecutor, then continuing a very long respected career as a prosecutor, and the attorney essentially did not witness, that's another RPC. They interviewed several witnesses the night of a shooting. It ended up being a murder. There was an eyewitness that had pretrial testimony that the defendant had been mistreated by the police. There was a criminal trial. Then the prosecutor brought this person aboard. The prosecutor recognized that they were material in a hostile witness. When they direct examined the witness, the attorney used street language. So he referred to the witness's boyfriend as her baby, and to her intoxication on the night of the shooting as being loaded. And he was being quite the swagger, using a lot of what he felt would be kind of street language to kind of make it seem as if he was relating to this particular witness. He also initiated the pronunciation of police, which was not the way he pronounced police. It was the way he believed that the witness was going to be pronouncing police. And he kind of like went back into it, and there was a whole argument about code switching and the way black folk talked and the way he was going to talk, and there was a lot of debate as to whether or not this was really appropriate. And what it really came down to was this was actually considered something which was not, his line of questioning was not considered entirely relevant. The way he questioned, it was not the questions that he asked. And this was not someone who was essentially disbarred, but it was just brought to the attention of discipline because there were, as you can imagine, it was very controversial. A lot of people thought it was just fine, and other people were pretty sort of offended by his tactics, and so it was considered more or less an irrelevant way to question the witness, and in fact disrespectful to the adjudicative process. So I just lay that out there as one sort of look at RPC 3.4. I didn't write it, so if you disagree with the result, I'm totally, it's just sort of an example of how that worked. So 3.5 is impartiality and decorum of the tribunal. And again, we're going to have, this is like getting you ready for these hypotheticals. So there will be a hypothetical that will address this to a certain extent. And that is, lawyers shall not be seeking to influence judges, jurors, or prospective jurors. The whole idea of communicating with the juror or prospective juror after discharge of the jury, and there are some very specific qualifications to that. And the lawyer shall not engage in conduct which is intended to disrupt a tribunal. So in your materials, there are various advisory opinions. One of them has to do with post-verdict communication with jurors. And what happened was essentially after the jury came through with their verdict, the county prosecutors decided to have a conversation with them, as they frequently do, and they decided to discuss excluded evidence to the jurors during post-verdict communication. And what was brought in with this advisory opinion was the issue of 3.5, and that is whether or not there was sort of an improper influence or whether or not the jurors had actually asked for this. And also another piece of this advisory opinion is 8.4D, and they actually pounded much stronger onto 8.4D because 8.4D is all about its professional misconduct for a lawyer to engage in conduct that's prejudicial to the administration of justice. What that meant was the lawyers were essentially kind of undermining the judicial process because the jurors post-verdict weren't necessarily going to understand why it was excluded. And so the comment was, well, this was excluded, what do you think of this? And it was the impact this was going to have on the jurors post-verdict that was considered sort of the biggest issue that arose as a result of that. There is a case in your materials about sort of the disruption of the process. It had to do with an attorney, and these are all public cases, by the way, which is why I can include them. And this particular respondent focused on a particular judge in Snohomish County Superior Court and would frequently refer to the judge's decisions as wrong and stupid in front of court staff. And then after the judge left the bench, the respondent made a loud screaming noise that could be heard in other rooms of the courthouse. Then when back in session, so this is like if you think you're having a bad day, read this case, because this judge really had several bad days when it came to this particular lawyer. The judge came back in, and the respondent began screaming again, and then that judge, it was a Judge Ferris, asked for security to be called, and the respondent turned to face the courtroom door, began to walk, and yelled, "I'm going to jail, I'm going to jail." She kept saying that as she left. She left, she was invited to come back in, then she became sort of belligerent to one of the marshals, and then she was defiantly invited, being taken away in handcuffs. And then about a week later, she went to the Snohomish County Bar Association office, continuing to behave in an agitated, unprofessional manner, and swore at one of their marshals at that point. Then, some period of time later, she went back, only this time it was to the King County Superior Courthouse, and basically came upon a marshal and decided to essentially to kind of engage that marshal, was sort of attempting to do that. He told her that she would be asked to leave, and so they went back and forth, and then a second marshal came and told her to go about her business, and then she left, and then she pretended like the first marshal tripped her, and then she called 911 on her mobile phone, saying that the marshal had tried to trip her, and it kind of goes on and on and on. But I mean, so sadly, there is sort of this issue, and one of the RPCs, there is not just one that was cited, was engaging in conduct intended to disrupt a dispute at a tribunal. So that's like kind of an exaggerated example of that, if you will. Truthfulness in statements to others is all about, in the course of representing a client, a lawyer shall not knowingly make a false statement of material fact. So truthfulness is very important, but there's no affirmative duty to inform opposing counsel of the relevant facts if they're not doing the digging themselves. And I do get some calls on the ethics line from attorneys that are very concerned about really the competency of their opposing counsel and what is their responsibility. And it's an adversarial system. We're not talking about competency like falling down and having, drug issues, but just really somebody's just not hitting the mark. 4.1 is often used in mediations. I just recently did a presentation on mediations, and we talk a lot about the idea that there's sort of an allowance in a mediation context for puffery and for sort of an exaggeration of maybe an ankle injury. My client has been sore, it's been really difficult, it's been an emotional issue. But to say that a sprained ankle is actually broken is a false statement of material fact. So there are lines that are drawn even in that context. And then the last RPC that I want to review, I want to do so because we call this kind of the Christmas tree RPC, because this is the one that, if you can't find it in any of the other rules, you're going to find it in RPC 8.4. But also in looking over what your agenda was, I want to alert you about a change in 1.2 and a change in 8.4 as it results in cannabis. And I understand that that has been part of your emphasis today. So when the recreational marijuana was legalized under I-502, the Supreme Court asked the Committee on Professional Ethics to make to address the issue as to the fact that there was this, more or less, this conflict between the state law and the federal law. And back then, which wasn't so long ago, the Committee on Professional Ethics recommended, and there's an advisory opinion as well, to the Supreme Court that there be an additional comment number 18 to 1.2. Now 1.2 is the scope of representation, and that is the emphasis 1.2 is lawyers can't really assist or counsel their clients to engage in criminal or fraudulent behaviors or actions, right? But I'll get to the 8.4 connection in a minute. Just hold on there. I know you're all just at the edge of your seats. But so what happened was that was put in the context of Comment 18, at least until there's a change in federal enforcement policy, a lawyer may counsel a client regarding the validity, scope, and meaning of Washington's marijuana laws, and it cited I-502, and I'm paraphrasing it, right? Well, there's been a change in federal policy. We don't really know to the understanding of how that's going to be enforced, but the Cole Memorandum just seems like 1900, right? I mean, it seems like a long time ago. And so more and more attorneys, and I'm happy to say they were getting concerned about their ethical duties and responsibilities. And interestingly enough, sort of the one that sort of brought this to the forefront was a city attorney, because the city attorney was essentially providing legal advice to utilities who were providing the power and water to grow operations. And so, you know, the city attorney has a responsibility to their client under 1.13 and under 1.2 not to essentially get them in deep trouble in that regard. So the court on September 5th, effective September 25th, so just last week, made some very significant changes to RPC 1.2 comment 18 and then added a comment to 8.4, which is misconduct. And so I'm going to read those to you. If you get on the court's website, you can see this because it's just been published. And so they took out that troublesome clause, at least until there's a change in federal enforcement policy, And it said, this is under 1.2, paragraph D, a lawyer may counsel a client regarding Washington's marijuana laws and may assist a client in conduct that the lawyer reasonably believes is permitted by those laws. If Washington law conflicts with federal or tribal law, the lawyer shall also advise the client regarding the related federal or tribal law or policy. So that took out the conditional aspect. It said, lawyer, you need to know what are the different implications for your client, and your job is to tell your client what those implications are. But what's also very interesting was the Committee on Professional Ethics brought to the Board of Governors approved an additional change to RPC 8.4 because, and I'm just telling you sort of like, this is not like codified, but the concern was, okay, if a lawyer's being sort of disciplined through the federal authorities, are they then subject to the misconduct part of 8.4 under our disciplinary system? Because lawyers are disciplined under the RPCs, right? And so there's an additional comment to 8.4, it's comment 8, new comment number 8. A lawyer who counsels a client regarding Washington's marijuana laws or assists the clients in conduct that the lawyer reasonably believes is permitted by those laws does not thereby violate RPC 8.4, and it references comment 18 to 1.2. So what that means is it provides, it says to the lawyers that are barred in Washington, if you are engaging in this kind of counseling to your clients, because quite frankly, we believe if it's been made legal, the public needs lawyers to help them go through the process, then it's not a violation of the rule of professional conduct, and so the Office of Disciplinary Counsel will be basically staying away from that whole piece. So the Supreme Court moves extremely slowly on so many things, but I have to tell you, it was a matter of weeks that the Supreme Court actually moved on this, so we were all very excited about how that worked. So, so that's the romp through the rules of professional conduct. We are now going to romp through several hypotheticals, and we're going to sort of take turns with the leading off of those hypotheticals as well. So before we move to that next section, does anybody have any questions or comments about what we've been talking about? You can certainly ask them later, but feel free. I can be interrupted. It's okay. I can handle it. All right. Good. Great. Thank you.
Okay. For the next section, I will read a hypothetical, and then I will give you 3 minutes to talk about it amongst yourselves, and I will get your attention back, and then we will give our comments, and then we will hear your comments on that. Okay. So the next, hypothetical 1. In a workers' compensation appeal, a medical professional testifies that the claimant needs a type of treatment that has been widely criticized in the medical community and news media as quackery. A small group of medical professionals, including the testifying witness, publicly disagree and have set up a successful business charging exorbitant rates for a treatment. So I'm going to give you 3 minutes and talk about it with someone next to you.
Don't worry. I'm like
Okay, so what is sit over my script.
I should film right now. Right.
Okay, everybody, we're ready to come back for our discussion. Thank you for your attention. Okay, almost ready? Okay, all right. So I'm going to give my opinion first here. At first glance, when I looked at this, I thought, of course, about the rule about presenting false testimony or false evidence. And then I thought, well, maybe this medical treatment isn't quackery and things are subject to opinion. And I immediately began thinking, well, what's the attorney's frame of mind in presenting this? Is he engaging in quackery because he knows it's a scam, and is he even profiting from it? When I saw the line about the high price, I thought, I wonder if he's getting some sort of financial reimbursement here or something like that. Anyway, but evidence can be controversial and it's subject to opinion. So my opinion on this is that if the attorney was presenting that evidence in good faith, that it would be okay. But I am disturbed by words like quackery, because I thought, if it is quackery and you know it, you should be ever presenting it. So I'd like to hand this off for other opinions.
Okay, I'm aware of cases that have made it to the Supreme Court regarding quackery. So I don't think it's at all unusual that people will have different opinions. And I think that your experts are allowed to disagree. I mean, it can be quackery to me or you, but someone else believes it, and therefore they are entitled to that. Fortunately, we do have some standards. I'm getting a lot of feedback. Like regarding Fry and Daubert, that hopefully that if somebody really questions it, we can go that way and explore whether it's really valid or not. I think the ethical issue is whether or not, as an attorney, you can put it on if you know it's a total pile of poo. But I think that that's a matter of degrees and how certain you are of that.
So I highlighted for you before comment number 8, which talked about the prohibition against offering false evidence. And it says only applies if the lawyer knows that the evidence is false. But, the lawyer, how does the lawyer know this? And you could have 98 folks that say it's quackery and 2 folks that say it's not, it's really legit. So it's a little tough, I think, to put a lawyer in sort of a decision where they have to, create that value decision. I think that in a sense, that's what the whole adversarial process is about. And in fact, that may be, opposing counsel's job, if you will, to try to poke holes in whatever that evidence is using legal theory and ethics theory. So I would say probably one would lean on the fact of if there's some scintilla of, credibility that this evidence should be offered, it's probably okay to do that. But I also want to talk about RPC 1.2, and that's the scope of representation. So if the client is pushing the lawyer to put on some sort of testimony or to provide evidence that the lawyer knows or reasonably believes is not an appropriate route to take, then you get into sort of that he said, client said struggle of whose decision is this, right? As to how to actually conduct that case. And there is a comment to 1.2, which I very much like and refer to a lot, and it talks about clients normally defer to the special knowledge and skill of their lawyer with respect to the means to be used to accomplish their objectives, particularly with respect to technical, legal, and tactical matters. So that kind of puts that piece over to the lawyer, right? And then the clients, the lawyers usually defer to the client regarding such questions as to the expense to be incurred, concern for third persons, but essentially, what is the bigger picture? What's the end game? And the lawyers need to remember, A, it's the client's case, but B, the lawyer is actually there to facilitate this through the legal system. And if the lawyer has an absolute disagreement with what the client is telling the lawyer to do, and I don't know about you, but I do get lots of calls on the ethics line from lawyers that are very frustrated by their clients. And they can't explain this to anyone else, really, but the client is pushing them to do something or to go in a direction that they don't want to go to. Then the lawyer has to do some really thinking and communicating with that client as to how far does that lawyer want to go and essentially be more or less kind of ruled by what that client wants. And I suggest to lawyers often that if the client is being extremely aggressive and will not let the lawyer sort of assume the role that the lawyer should be taking in that proceeding, the lawyer really should be thinking long and hard as to whether or not they want to continue to represent that client, because that's the first client that will contact the Bar Association if they don't like what that lawyer did after, or they don't like what the result was. And, it's sort of like it's setting up sort of that tension or that dynamic. Now, some lawyers, like public defenders, don't always get to just say, I'm sorry, no thank you. But, it's just kind of something to bring out in that regard.
Okay, any comments from other folks?
Any other RPCs we missed?
Well, I got one.
Yeah.
If you're the ALJ hearing officer and you have the general knowledge and then one of the parties is pro se unrepresented and the other attorney is, making the claim that, is questionable in the media, is a role as an impartial person, but again, in an informal setting, how appropriate is it to raise some of the concerns that are general knowledge out there? This is informal here.
Well, it's not a judge, but I would say, first of all, a judge can make a credibility finding. So the judge can simply find this evidence not credible.
Could also make them prove up under Fry. I mean, you could say, I need to know whether it meets any scientific standards and what's your evidence that it does.
And the other thing I would say, without having sort of an intimate knowledge of that process, is a judge needs to be careful that they're not jumping into being an advocate from one side or the other. I mean, they are a third-party, neutral adjudicator in that regard. And as I understand it, there are many, many judges that are very frustrated because there's a high number of pro ses that are appearing in front of them that don't kind of understand sort of the properness of what the proceeding should go. And that's a difficult thing to be, but a judge still can't be an advocate for somebody that they may sense really is getting sort of buried under the attorney. So do we have any other suggestions from the back of the room there? Or no, Roman, you got a comment on that? Do you have any thoughts on how that would go as an adjudicator?
I sort of stepped out of the room for a minute to try to grab it back. So I missed
I gotta tell you, I've heard that excuse before. Okay, sorry to put you on the spot. But the whole piece is you've got one side which is basically being buried by some sort of expert type of testimony, which could very well be very quackery. And how what does the judge do and how do they intervene? And yes, sir.
Well, isn't it the development, as administrative law judge, it's the development of the record? In other words, I don't have to believe it or disbelieve it at that point. I have to allow the pro se to make whatever record he or she chooses to make. And then, as one of the other panelists spoke to, I can make a credibility determination after the case is over, or I can weigh that evidence in comparison to the evidence that's put on by the other side and make a determination then. I don't think that necessarily puts us in the position of being advocates for one side or the other. It's just asking what open-ended questions I think will elicit the evidence to allow me to then reach a decision at the end of the case.
So what if your open-ended questions do not elicit the evidence that I think would help you determine that this really is not a well-founded approach to take? I mean, can you do any kind of independent research? No. So the credibility finding, to me, not being in the process, must be based on what's actually been brought out in the courtroom. But if the tribunal is asking those questions but not getting those answers, the credibility finding isn't really based on a full position on both sides. It's only based on a full position on one side. It's just a thought here.
A credibility finding is credibility finding, period.
Okay, yeah,
So you're making the assumption that the judge doesn't have enough
Right,
expertise
that-
to make official notice, to at least raise the issue and then thereby allow the parties to make whatever argument they're going to make. And
Well-
introduce it that way.
right. And I would hesitate to have a judge be an expert, essentially, but what if the party that's the pro se party is not actually building up the evidence that they need to as a result of that? That's a conundrum. That's my only thought in that regard. So, it's almost like a good textbook approach, but in reality, I'm sure it's far more difficult in that regard. That's why you all have the corner offices, right?
Big bucks.
Same here, don't worry.
Yeah, sure. Okay, the next hypothetical. In a licensing case, the department asks counsel for the license holder whether the license holder has had any previous convictions. The license holder had a juvenile conviction which was sealed by the court. Discuss. So you want to take a couple minutes and then we'll talk about it? See where we are. Anybody want to volunteer? What do you think? Anybody? Yes.
We had a question because we don't practice in this area. We don't know what it means when a case is sealed, whether that means you're allowed to say no or not.
And I had the same question because I will tell you that when you look at the RPCs, and as Jean Marie went through it with us, there was a couple of them that kind of apply to this. 3.4 and 4.1 both talk about that you can't lie to the other side, mislead people, stuff like that. So my first gut instinct is, well, you got to tell them. You can't not tell somebody. You could argue that it's not admissible, but you can't not tell them. But anybody know about this? Who are my juvenile litigators? Anybody do this criminal defense stuff? Somebody, there's a few. What is the law? Do you know?
You don't have an obligation to share, the license holder doesn't have an obligation to share that information.
Right. Because under RCW, I had to go look this up after I got the hypothetical because I didn't know this. RCW 1350-260, subsection 6 says, if the court enters, it's a whole lot of stuff about how you go about sealing, And then it says, if the court enters a written order sealing the juvenile court record pursuant to this section, and the stuff that says, thereafter the proceedings in the case shall be treated as if they had never occurred, and the subject of the records may reply accordingly in an inquiry about the events, records of which are sealed. Any agency shall reply to any inquiry concerning confidential or sealed records, that records are confidential and no information can be given about the existence or non-existence of records concerning an individual. So it's a kind of unusual one. We don't have a lot of statutes that say that you can actually like disregard the truth and act like it didn't happen. But there are some cases where that gets nullified, just so you know. If don't just take it as a blanket thing, go read the statute. If you have further juvenile convictions after one's been sealed, it nullifies it. If you have adult felony convictions, it can nullify it as well. So it's not an absolute.
Do you have a question?
Yep. Okay, any other, my panelists, anybody have anything to add on that? Okay, oh, you do?
No, but I just learned something new today. So yeah, I'm all about 3.3 and duty of candor to the tribunal, except, for RPC 1.6. And I read through the rule again and looked for the comments, and, some of these RPCs sneak in or as otherwise permitted by law or something like that. I don't see that in 3.3, but so I do see that as a very interesting point. But after looking at that statute, it seems really clear. It's like it never existed unless it's been nullified. So yeah, thank you.
All right, the next one, you want to move? Hypothetical 3, the issues in a case require detailed calculations in order to reach the proper result. In a discussion between the attorney and the expert witness before trial, the expert witness comments that the area is squishy and that there are a number of possible results that you can reach depending on the inputs you use. During cross-examination, however, the expert is asked whether there is any ambiguity in the calculation, and the expert answers no. Discuss. Okay, what do we do in this case? What do you do? Let's assume that it is your expert, you are putting on one side of the case, and it is your expert that you put on. This is what they told you before they testified, and then they answered a question differently than you'd expected. Never happened to anybody before, has it? What do you do? Anybody? Yeah. So do you go back and try to make it unsquishy? What do you mean?
Oh, so he has answered not quite what he told you.
Right. Right.
Do you have a duty to?
That's the question.
I know.
Okay. He's answered somehow differently than what you expected him to say. What is your duty? Do you have a duty to go back and fix it?
Yes.
I see a lot of people nodding yes. Yes, sir.
Yeah,
I think you have a duty to go up to the bench, do a sidebar, tell the judge that my witness just testified inconsistent to what he told me in the hallway an hour ago.
A lot of people disagree with you. Yeah.
I think if you just go back and say, did you previously tell me there's more than one way to do this calculation? Just ask another question.
And just clarify it that way?
Yeah.
But it's not during your.
Yeah, it's not your case yet. It's during the cross-examination. What do you do? Well, what I thought is I would, at the next reasonable spot, I would ask for a brief recess to talk to the witness. You don't leave a question hanging, but, ask for a recess. I'd pull the person out and say, okay, something happened here. I thought you said this, but then you just testified this. Did I misunderstand the question? Did you misunderstand the question? What's our disconnect? Because I can't leave, in my mind, you have said something different, and that's not comfortable for me, so I need to know so we can clarify it. And either then, they get back up and they say, I need to correct my answer, or I do it in my redirect afterwards to fix it. But I would be very uncomfortable not addressing that quickly, but I would not do it with the judge until I talk to the witness, because it could be simply that they misspoke, they misunderstood my question earlier, they misunderstood the question being asked, the question was slightly different, and because of the way it was asked, both are correct. I mean, who knows? But I'd want to know that from the witness. Anybody disagree or? What? You would do that? Okay, you would do it, take it to the judge? Anybody else? Chris, you bet you want to say something? No?
No, I wrote the hypotheticals, but I don't know the answers. So.
All right, how about my fellow panel members?
Well, I think, there's a couple of RPCs that would apply to this, but I think primarily RPC 3.3, and that's a duty of candor to tribunal, and then there's the whole tension between 3.3 and 1.6, which is confidentiality. I think the biggest mistake an attorney could make would be to ignore it and not address it. So I really would agree with your approach, Tracy, and that is essentially to try to make sure that you're eliciting sort of the truth, if you will, about that particular testimony, because to me, it's material evidence, and you just found out that that's the wrong authority, or it's not there's something really profoundly wrong with the evidence, and you actually have a duty to figure out a way to put that evidence on there in the best way, because if you don't ask those questions, opposing counsel is going to be asking those questions. Better that you elicit that than your opposing counsel in that regard too. Yes, sir. In the back?
So I read it perhaps in a legalistic way, because I'm looking at the words. The calculation is different from the inputs that you use. If you assume the same inputs, there's no ambiguity in the calculation based on those inputs. If the hypothetical is to say, well, if you use different inputs, you get different results, well, then that would be a different story. But the naked math, there's no ambiguity in the naked math. I would do nothing.
You would do nothing? See, because to me, my thought was, that's why I wouldn't take it to the judge, because I'd want to give the witness the chance to explain it to me in case it was, if my gut is that he's just lied, I need to fix that, then I need to know how I'm wrong if, yeah, Roman?
That's the position I would take as well. I think ultimately you can't suborn perjury. And so if you believe that he's misrepresented something, and we're talking about calculations, something that I would say to go further, something that can be verified later. At the end of the day, as attorneys, all we have is our credibility. And if you're willing to sacrifice that because you're willing to paint the gray area or something like that, then that's your call. But I would say if you believe that he or she has misrepresented something, you have an obligation to try to clarify that in some kind of way at some point. And so, because no good can come of it if you're called on it later. Right. It's too late once somebody calls you on it. I think that the best practice would be to clarify it yourself. You can always rehabilitate your witness yourself, but it's something different. It's more difficult once that witness has been called a liar.
Yeah. I've had it come up probably most often more in a deposition where somebody starts using the wrong year, and then they keep saying the wrong year, and you know it's the wrong year, and you're like, at what point, you know, and finally, a lot of times I'll say, okay, can we take a quick second for a minute, and I'll just say, you know, you keep saying 2012, but I thought it was 2014, which, you know, and let's get it clear and make the rest of the record correct. And I'd rather do that on the record so that it's not like I coached them to fix their answer, but it's like, I'm confused, you know, and it's not just, you know, I'm confused, help, you know. So it's really not that I'm trying to coach somebody into something, or somebody keeps using the wrong name. You know, in our cases, we're dealing with patients, and it's like they start talking about patient B and they really meant patient A. And all of a sudden, the whole deposition is going to be a complete waste of everybody's time if we don't clarify it and move forward with the correct information.
So I like your observation about the pure math piece, and I understand where you're going with that, but I'm thinking that if there's some confusion on the part of all of us that are reading this, there may be confusion on the trier of fact or whomever's actually listening to this. So even if the pure math, that answer is correct, I think I would suggest that the line of questioning just kind of say, so this sounds a little different. Can you just be really clear about what you mean by input versus the calculation, just so that we know that there's no confusion about the yes to one answer and the no to another. So, because, you know, clearly this has elicited some misunderstanding on just about everybody in the room. So great hypothetical there, Chris. And were you going to further comment on that, sir?
I'd just say that in an adversarial setting, we should be able to rely on opposing counsel to highlight the ambiguities or the weaknesses of the testimony of the witness without having an affirmative duty to clarify something that may be perfectly clear to the attorney presenting that witness.
Oh, I would never wait for my opposing counsel to take care of my witness for me at all. I'm sorry, I would not. I would make sure that I did it myself, but I understand that piece. I want to do it because I want to make that witness look as good as they can in that explanation, and I don't know how that opposing counsel is going to frame those questions and how that person's going to look. So I really trust what I do more than I trust the that regard. But anyway, good thought.
All right, we're ready to move on to hypothetical 4. Can you do the PowerPoint? One party is represented by a lawyer. Another party is not. During the course of a mediation, it is revealed that a lawyer for the represented party told the self-represented litigant that he had no case. But in order to get the case off her desk, she would be willing to pay $500 in exchange for a dismissal to discuss. So we will give you 2 minutes.
That's why I was saying,
Okay, I think we're ready to open this up for comments now. All right, everyone? Okay. We've had a request from our host that if you are making a comment, hello? Okay. We have had a request that if you are making a comment, to speak up really loud, okay? So this hypothetical about the settlement offer. Any initial comments from anyone? Okay, go ahead.
Well, we were thinking that as long as the unrepresented party didn't get the impression that the attorney was somehow giving them legal advice, then it would be just your straight, you making a deal to dismiss.
Any other comments?
RPC 4.3. You got it. The attorney cannot say or show that they're disinterested. They always need to let an unrepresented party know that they represent someone in the process. Yeah.
Any other comments? The first thing I saw when I looked at it, I was concerned that this attorney's making a settlement offer to a party that's not represented. And, you know, my first question, why is this party not represented? But I thought about that if the party was represented, of course, you would have to deal with the representative and not the party themselves. So that's an important issue. And another issue is if there is a settlement offer, his client or her client should be aware of that, you know, that it should not be just made on their own. Any other?
Yeah, so when I read this, I thought to myself, I was concerned that the lawyer was trying to get this off their desk and was going around the client. Or was essentially divulging confidential information under 1.6. Maybe that lawyer had a conversation with that client. The client said, you know, you do the negotiations, I don't want to get involved, but, you know, probably I'll take 500. But to your point of 1.4, communicating with the client and saying, so now I'm going to go and offer this, is really the appropriate way to do that instead of essentially putting the lawyer's interests of, I've got too many cases right now, I want to get this off my plate. Let me catch this person in the hallway, let me tell them, you know, you and I, we can get rid of it for $500. I think that's a huge problem when it comes to RPC 1.6. And also sort of the 1.2 scope of representation, and that is if the lawyer and their client are having a disagreement over the value that the client should take, guess whose word gets the last word? It's the client under 1.2. So sort of reading into the hypothetical, but that's where I would have taken that. Any other comments or thoughts?
We wanted to ensure that it wasn't the attorney's money being used for the settlement.
Yeah, let me get you the RPC that speaks to that very specifically. And that is RPC 1.8. E, a lawyer shall not, while representing a client in connection with the contemplated or pending litigation, advance or guarantee financial assistance to a client, which essentially means they can't put themselves in the position of a client in sort of any matter of the case. And that the lawyer shall not, under I, acquire proprietary interest in the cause of action or subject matter that the lawyer is conducting for the client, with some very, very limited exceptions. So yeah, the lawyer can't kind of can't go behind the client's back.
So good instincts.
Yay. Good or bad, I'm not sure which. But.
All right, next one. A lawyer who has practiced in front of the same tribunal for 20 years has begun to miss deadlines, present bizarre, sometimes irrelevant evidence, and make angry outbursts in proceedings. His clients do not seem to be aware of his strange behavior. At the most recent hearing, he failed to ask a witness a question necessary in order to prevail in the case. Discuss. getting us out of here on time. I'm gonna cut it off there. What do you think? Laura, what would you do? Your position as a judge, what would you do? She's leaving, so I don't have to appear in front of her anymore. Can't get me back.
I'd be tempted to report the lawyer to the bar.
To the bar. Anybody else reported to the bar?
No.
No? What would you, why not? Who said it?
Obviously, somebody needs help, and I think what you would do, maybe have someone who's not involved with this proceeding, maybe another judge, call them aside and ask if they need help.
Okay. Yes.
Can I just respond? The bar actually has resources. The bar is not just discipline.
Yeah.
So but when we say report to the bar, probably a better word would be to get in touch with the bar. We actually do have a lawyers assistance program. It's not quite as robust as it used to be, but there are resources. And the whole idea of reaching out, maybe even getting anonymous help, or even looking at WSBA.org for different resources. There's WISPA Connect for every licensed legal professional in Washington. There's actually access to through your bar. There's like access to counseling, financial counseling, all sorts of counseling through that at no cost to lawyers.
Yeah.
Well, I think you could also reach out to their partner if they had a long time partner in their firm and have a kind of a light conversation with them, touch base.
Okay. So reach out to somebody who knows them.
Yeah.
Anybody else? I think this is a really hard one, and I was trying to think of in my own practice. I mean, we deal with lawyers that we sometimes question whether they should have a license or not, but this is kind of geared as a change in behavior. I will tell you, I had a time when I used to be a prosecutor, and the defense attorney on a case that I had, who was a friend and somebody who I liked and respected, we had a trial that day, and I believed he was intoxicated that morning, and I was like, I don't know what to do with this. And so I went to my management, who contacted his management, who brought somebody else down and took care of it. But it was like, I can't go forward. I mean, it's a very uncomfortable feeling. But, I've always been a government lawyer, and I guess, one of the things I like about being a government lawyer is I always feel like I'm wearing the white hat. I'm on the side of, seeking justice. Could I have, gone forward with the trial and railroaded him? Probably, but that's not justice. That's not appropriate, I mean, it's just a basis for an appeal later anyway. So, I mean, that was, my solution on that one, but I don't know if it was a solo practitioner, what would I have done?
One thing that stands out from this is the issue of him failing to ask a question. Sometimes that can be a strategy issue, and it's questioning someone's judgment about deciding which case or a question. He may actually be making a conscious choice. It might actually be in his client's best interest. I have a lot of discussions in my office about what's appropriate cross-examination, and often what people think is a good question is really harmful to their own case because it gives the other side opportunities to explain. And I think that with this issue of the behavior, I think if I were reporting it to the bar or counseling, I wouldn't focus on that. I would focus more on the more objectively disturbing things.
So depending on your relationship with this attorney, so we're talking a lot about what we would do in the moment, but there might be some consideration with you when that case or that matter has moved on, having a conversation with them. I mean, it was like a law school classmate or somebody that sort of like, how are things going? How are things at home? Or, how are things in that regard? And maybe even on an informal basis, not sort of in the context of a tribunal, offering them some help. We were chatting about this earlier. I mean, the ABA came out with a survey that we've always known that we're in one of the most stressful professions, but my goodness, it's really manifesting itself through substance abuse, through depression, through suicide rates. There's all sorts of things that are very problematic with all of us practitioners in the adversarial system. And so maybe what we need to do, in addition to what we've already talked about, but acknowledge that and work on, trying to get more resources or less of a stigma on folks that may actually need some help in that regard. So, just sort of another consideration for this whole piece.
And going back, Laura, one of my first thoughts was, what does the bar offer? And so I do think that we should always be thinking about that. I deal with discipline of medical professionals, and we have programs and people can be referred to those, and the disciplining authority never even knows that they're there. That's a safe, confidential way to get somebody the help they need. So I think that's a great
I
option.
occasionally have had people call me on the ethics line just because they know who I am, or they've just kind of been in touch with me, so I'll just find it on the website. It's not an ethics line call, but I'll steer them in the right direction. So, it's really intended to put a hand out.
Do you want me to go into this?
Was there a question over
Oh.
there?
Yeah, so in this situation, do you continue with the hearing? Do you take a pause and realize that there's an issue here? I mean, in your situation, Casey, I think you said that after the hearing, then you said something, but.
No, for mine it was before. I was not going to go forward to trial
Okay.
with someone who I thought was intoxicated. So, but yeah, I think the question is the level of degrees, and I don't know. I mean, we use in an informal setting around the office, we talk about certain people, well, she's crazy, she's crazy, that kind of thing, as if, well, we all know that attorney's crazy, but honestly, at what point are they not representing their client? You know what I mean? At what point do you have an obligation as the attorney on the other side to do something about it? And I don't, I honestly don't know the answer. I think it's a level of, degrees. So.
And I think all of that has to be framed to a certain extent. I would just ask that you keep aware of 1.6, and that is confidentiality. So how much do you go outside of that attorney-client relationship to begin to discuss the behavior of opposing counsel when in fact that might be breaching some sort of confidentiality with your own client as well? It's never an easy answer.
Okay, moving on. Oh, more question or comment? Yeah.
I just wanted to add that as attorneys, we are supposed to be a self-policing profession. And if we don't do it, we're inviting other agencies or other types of law enforcement or the public to do it. So we really
For those that couldn't hear, what she's saying is, as attorneys, we are supposed to be a self-policing profession, and if we don't do it, we're basically forcing others to have to do it. And I also think, adding to that, it goes to the credibility and the respect of our profession. We're not very well respected as a profession, and if part of it is because we don't self-police and we don't take care of the problems, that hurts us all. We got 10 minutes left, so.
Want to go on to next?
Do we keep doing this way, or have you guys want us?
So shall we go on hypothetical number 6? Okay. Can I just say, we usually use the word self-regulated, not self-policing. It's just sort of it doesn't get it right the same way. Shall we go on to 6? I think. Okay, great. All right. A lawyer in a case has made casual comments to your staff that you and your staff find to be offensive. You have mentioned your concerns to him or her before and asked him to stop. He continues to make the comments. Another judge has reported that he has made similar comments on the record. According to the judge, opposing counsel and witnesses were shocked by the remarks. Please discuss. Oh, we know this lawyer? Okay. These are all hypotheticals. There is no connection to anyone that's real or, not in that order. Besides, Andrea, what do you think?
I don't know what you mean by this hypothetical, Tracy.
You've never seen this kind of
I've never
situation?
seen a lawyer do that, make those casual comments or scream into a phone until I hung up on, a person hung up on him.
Yeah, I can only imagine who made up this hypothetical, but it bears a remarkable similarity to someone who we deal with. I can tell you, for me as a supervisor in my job, what I have been able to do is I can tell my people that you do not deserve to be abused, and if this person abuses you or anybody abuses you, you are welcome to hang up on them. Just tell them that you're doing it, so there's not a surprise. Say, if you don't stop doing that, I'm going to hang up, and if they don't stop, you hang up. The harder thing for us is when we're on the phone with the judge and it happens there, or when you're in a deposition and it happens there, and things like that. So, thoughts? Nobody else has this experience. Roman?
Personally, I think that let's say for instance in a situation where it happens on a call and the judge is present, I think the judge has an obligation to maintain order and decorum in that call. And whatever that looks like is up to that judge, but I think you have to call that person on that behavior. And it helps when, when the opposing counsel, when they're not dismissive of the comments, but certainly I think the judge has an obligation to, because if you don't, you're almost, you're inviting it for the next time, but you're also saying it's okay. And so I think you're going to expect, you should expect to get it again, and maybe worse, depending on that particular attorney. So I think there's some obligation, a huge obligation on the part of the judge to speak up and stand in the gap. Maybe not necessarily protecting the attorney, but you're protecting the process and you're protecting the forum and the tribunal.
And I think one of the hardest things is when somebody is personally attacking you, to not reciprocate or to defend yourself. And that is really, really hard. And I can say I failed at it many times when somebody has, I have certain buttons, and if somebody questions my integrity, that's one of them. And I can feel my, blood pressure rising, that kind of thing. But, actually, Roman and I have talked about this. The best thing for them as a judge hearing it is if we don't engage, then it's obvious one person abusing the other, versus if we engage, then it's really easy to say the whole thing got out of control, both attorneys were yelling, that kind of thing. And it's hard to blame somebody when it's someone that, does this a lot, but it's take the high road. Take the high road. Every time that you can, take the high road. Other thoughts? I know we're down to like 3 minutes left, right? Literally 3 minutes left. Oh, yes.
So sometimes it sort of really depends on the context, and I will tell you that this has happened to me more than once. Sometimes apologizing, even when you don't want to apologize, I'm really sorry that comment has really upset you. I mean, it's not actually taking ownership of the comment. Sometimes I have seen that kind of de-escalate situations where all they want other people to do is to take a certain amount of ownership because they're so tired, they're so upset, they're so angry, and they want to spill it over onto someone else. I mean, it's just kind of like trying to look at it more from their perspective too, which is, I agree, is really hard. But I want to bring this back to the RPCs because I want to finish up with the RPCs. So that whole 8.4, we're looking at is professional misconduct for a lawyer to engage in conduct that's prejudicial to the administration of justice, to commit discriminatory acts prohibited by state law on the basis of sex, race, age, creed, religion, color, national origin, disability, sexual orientation, or marital status, and now veteran status. I took that the comments could be very offensive into any one of those categories, and I don't know about you, but I certainly heard a lot of those, particularly when I was a young lawyer, and they were gender-based. And also as professional misconduct for a lawyer to represent a client and engage in conduct that's prejudicial to the administration of justice towards judges. And so if those are also pointed towards judges, there's another piece of it. There's acts involving moral turpitude. There's sort of the bottom line is engage in conduct demonstrating unfitness to practice law. So, this is a reminder to the lawyers, all of us, obviously, none of us in this room need to be taught this, but that kind of behavior is really something that's applicable to the rules of professional conduct. And last but not least, when it comes to the reporting piece, 8.3 in Washington, it is not mandatory to report another lawyer to the Bar Association in the grievance context. So if you're encountering that, you will not be penalized because you choose not to report that to the bar. And there are lawyers that are trained in other jurisdictions where it is very different. And the other piece is if you choose to report that to the bar, you cannot disclose confidential information under 1.6 unless you get the informed consent of your client. So you can't just go make a beeline to the bar and file a grievance against that lawyer. If it happened in the context of the attorney-client relationship, you've got to get the informed consent of the client. John has a comment.
That's it.
Yeah, that's it. So thank you very, very much.